Just so that we know what we're talking about here, we finished up talking about the different types of agency relationships. That's where we ended Thursday. And we kind of went a little bit further, and we'll skim over the first parts that we talked about, but then we're going to get into sort of the number 3 and number 4 here, and those get a little more complicated. When we talk about single agency, we just mean our company either represents the buyer or the seller, but not both. Not both in a transaction. Okay, we will not. So if I have the buyer, nobody in my company is going to bring the seller, right? Or we're not going to see anything in our company. If I have the seller, if I have the listing, nobody in my company is going to bring the buyer, because our company would be a single agency. So we either have the buyer or the seller, but not both. And we'll talk about that, what both is in dual, and when we talk about dual agency. Now, the difference is when we have a listing, everything's all good. Okay, we're going to have the listing, and we're going to have the listing. We'll sign a contract right away. Boom, a listing contract happens. Before we can do anything, any kind of advertisement, we have to sign that listing contract. We have to get it. And we're going to talk about that in chapter 8. But buyer's agency might be a little different, because we can have what's called an oral buyer's agency. Now, the best thing for us is for us to go ahead and get an oral buyer's agency right away. It'll just make life easier. They'll be work exclusive with us. We'll have a start date, we'll have an end date, and it'll give us the ability to speak freely and use our advice and counsel and judgment and help them make a decision. But a lot of buyers are a little apprehensive about working with agents. So North Carolina kind of gives them a little bit of an opportunity to kind of get familiar with you. So they can go to and say, we want to be an oral buyer's agent, or you can offer oral buyer's agency. And that protects you. That allows you, as the agent, as the broker, it allows you to speak freely, give advice, give counsel, as long as you're working under an oral buyer's agency agreement. Now, with that, you have to discuss 3 things right up front. You're going to have to give them the agency disclosure of brokerage relationships, which we're going to talk about in a very short period of time before this hour is up. Then you're going to ask them, tell them about compensation, how you're going to get paid, right? That's the second thing you're going to talk to them about. This is how we get paid. If the seller doesn't pay me, then I have to come to you and get some money. Do you agree to that? And then the third thing is, will they accept dual agency? Because that has to be disclosed, right? So while we're talking to somebody, if I have a listing and they want to buy my listing, that becomes dual agency, which we'll get into detail here. But those 3 things have to be talked about prior to us signing anything. The problem is this: even if we're working under a buyer agency, I cannot stop them from working with anybody else, and I cannot put a time frame on this. It could go on for as long as we see fit. Now, neither one of those things work in your advantage. The other part does, where you can talk to them and you don't have to worry about giving information to a customer, right? Because that would be an implied agency, and that would be a problem. You're not allowed to imply agency. Agency can only be obtained through a written contract. Before we can submit an offer, to somebody else, then we need to get that reduced to writing. So at no point can I submit an offer for an oral buyer's agency. All right, I can only submit it if we have it in writing. So by that time we get to that point where they're saying, I want to make an offer, we say, all right, well, we got to sign this buyer's agency agreement. Okay, so that's what happens with buyer's agency. It's still single agency. If we can't sell any of our listings, we only work with buyers. Our company might yes, and once they sign it, that's a good point, Tyler. Once they sign it, now they are exclusive and we are on a time frame. But until they sign it, no, we aren't, right? Once they sign it, they're exclusive with you. Now, if you go do all this legwork and they don't sign anything, and all of a sudden they see the house of their dreams, and they go to Uncle Henry and say, hey, Uncle Henry, I know you got a real estate license here. I want to buy this one. Why don't you take me over there and let's fill out the contract? Uncle Henry gives them a buyer's agency agreement. You did all the work. Uncle Henry gets paid. Thank you very much, Uncle Henry. I'm sure if you called him, he'll send you his warmest regards, but he probably ain't gonna send you any money, right? And you did all the work. That's why it's good to get these things in writing as soon as you can, okay? So that's buyer agency. Seller subagency. If the client hires my firm, everybody in my firm, all of us agents, aren't we all sub-agents? Technically, if I brought my brother into to sign up with our office, with my company, ABC Company, and I said, here, you got to sign up, you got to hire the firm. And he signs up and hires the firm. Is it okay for my broker in charge to say, all right, thanks, Sam, I appreciate it, but we're going to give this to Shanta today? Can he do that? Yeah, he sure can. It's his. It's his. He can certainly do that. Now, would he keep me as an agent for long if he did that? Probably not. Right? Probably not. I'd be looking for another place to work if that was the case. He's going to take my things I worked hard for and move them. Okay. So that's not going to work for me. But he could, anytime you represent the seller, you're the sub-agent. Yes. Right? You can only represent the seller if they hire the firm. Yeah, absolutely. In both cases. The only way you can get representation is if they hire somebody. In the seller's case, the listing agreement is the agency contract. The agency agreement. Okay. What happens we get to, remember I told you before, in order for us to make a claim for any kind of compensation, we have to be one of three things in North Carolina. We have to be the seller's agent, the listing agent. We have to be the buyer's agent, or we can be the seller sub-agent. Okay, seller sub-agent. So what happens is this. I get to, we get to the point where my seller or my buyer, we find the perfect house, right? We're an oral buyer's agency. We find the perfect house. So I pull out the buyer's agency agreement and I say to my buyer, hey, sign this off. Let me explain to you what's in there. And she says, you know, I'm not really comfortable with that. I'm going to let this slide. I'm going to do this on my own, which she can. Now, you're between a rock and a hard spot because you're not the buyer's agent. I mean, you're not the seller's agent. And now you're not the buyer's agent. So still now you have one more choice here. So what you can do is say, will you allow me, Mr. Buyer or Mrs. Buyer, to be what's called a seller sub-agent? Mrs. Buyer says, what's that? And what you're going to say is, with your permission, I am going to go and see if the seller will allow me to represent them as a sub-agent and get this transaction put together for you. However, good news, bad news. Good news is I can help with the transaction. The bad news is that when I go over to the seller, I got to tell them everything I know about you for confidentiality. Mrs. Buyer says, okay, that might be a good idea. So you go to the seller and you go and you find out the seller, you go to the seller's agent and you say, okay, Mrs. Buyer says that it would be okay for me to work as a seller sub-agent. So I want to go, and this doesn't matter what company you're with. I could be working for ABC Company and I could be calling XYZ Company and saying, let me work as a sub-agent so that I can, we can make some money. We can get this buyer and seller together. Well, the listing agent may or may not allow it. The seller agent may or may not allow it. Now, I'm going to give them all the information for the buyer if that's the case. All right. But what happens if my buyer decides to sue because she thinks I was lying to her while I was representing her or while I was doing all that oral buyer's agency? What's going to happen? she's going to sue me, and she's going to sue the listing agent and the listing agent's company because they now said that I could work and represent their seller. It's called vicarious liability. Vicarious liability. The person who is on ABC company or XYZ company, the one I went to and said, please let me work to you, they didn't have anything to do with me lying to my client or me misrepresenting the client or anything else like that. But they will get sued because they hired me to represent their client, okay, as a seller subagent. So if I am, first things first, if I told Mrs. Buyer that I'm going to go over to the seller and tell them everything I know about you so that we can get this thing corrected, is she going to say, yes, go ahead, feel free to do so? Chances are pretty remote that she's not. But if she does, maybe it doesn't bother her. I go to the seller. The very first thing the seller's agent's going to say is, I don't think we're good with that because I don't want to get sued for you in the event that she sues you, right? So does seller subagency technically, when we're doing it in that through that lens, does it happen a lot? No, doesn't happen a lot. Could it happen? Sure, it could happen. Okay. The issue is that if I'm the buyer's agent up until that point, I got to go tell the seller everything I know about the buyer, right? Because for my client, what do I owe? I owe those 6 things. One is what? Confidentiality for my seller, but also I have to tell them everything about material facts from my buyer. What do I know? How much can she pay? What's she looking to buy? All of those things. I have to give them up, right? Is there a difference between seller agency and seller subagency? Yes, seller's agency is the listing agent. They're the one who went out, found Mr. Seller, got him to sign the contract. They did all the marketing. They did everything else. Seller subagency didn't have anything to do with that, but now they got a buyer who is coming over, right? Coming over doesn't want to hire you as a buyer's agent. Your only way to get paid is to be a seller subagent, and the chances are not remote, are pretty remote that you're going to get it. But then you're going to have to walk away, throw your hands up. Let's say the seller says no, the buyer says no, right? Yeah, you would split it. Probably you would split it. Nothing's absolute, but yeah, probably. So now I have, what's going to happen is if she won't hire me, if she won't sign that buyer's agency agreement, I got to wave her on. I'll have to say, hey, see you later. Go do your own thing. I can't help her, nor am I going to get paid. That's why you want to get this buyer's agency done. Now, seller subagency, and also means that they hired the firm. So all the agents technically we're going to use the term twice. When we're doing seller subagency and we work from a buyer to a seller, that's one way. The other way is that everybody who works for the firm is going to be a subagent. If I died and I'm working that buyer's agency, does the buyer's agency go away? No, they find another agent to go take my place, right? Because the firm, this ethereal thing called the firm, they own the listing. They own the buyer's representation. So we're interchangeable parts when it comes to that. So that's what, they're all seller subagents also. All right, all seller subagents also. So that's how that works. Now, I got the best listing in the world. Yeah. And Mrs. Buyer, come on. Sign my buyer's representation agreement. Let's agree to dual agency. My seller says I'll be a dual agent. Why don't you come with me and I'll show you the perfect house? Okay. I'm going to be, as an agent or as a company and an agent, I would be in dual agency. I would have the buyer and I would have the seller. Lucky me. Okay. I would have to get them to agree in writing. Okay. So it says the broker represents both the buyer and the seller with equal loyalty in the same transaction with permission and without compromising either principle. Wow. First thing you all thought of was, wow, I'll get double the commission, right? That's what you all thought. Don't lie to me. Okay, don't lie to me. It's the hardest thing you'll ever do without breaking the law. Because what are the 6 tenets of fiduciary responsibilities? Obedience, loyalty, disclosure, confidentiality, accounting, reasonable skill, and care. If I go into dual agency and I have both the buyer and the seller, can I be obedient to both parties? Can't. Right? I can't. Can I be loyal to both parties? Am I going to work for one side more than the other? No, I can't. What about disclosure? Can I tell a seller what the buyers can pay? And can I tell the buyer what the seller is willing to accept? Can I do that? So I lose half of my fiduciary responsibilities. And I have to be a referee now. I have to be this referee. I still have to keep confidentialities for both parties. I still have to account for both parties. And I still have to use reasonable skill and care. But I'm going to act more as a mediator. Keep in mind that we have a buyer who wants to buy the house and a seller who wants to sell the house. But you don't want to give any bit of consort that says that the buyer thinks you're cheating with the seller thinks you're not giving her all the information from the buyer. So anything like that, you have to play it straight down the middle, right? You're a mediator, if you will. Think about it as a referee in a football game. That's what you are. All you want to do is conduct the game, right? You have no outcome of who wins or who loses. You just want to get this thing closed. All right. That's what dual agency does. Yeah, anyone can sue for anything. You're absolutely correct. And in a lot of cases you do, but I don't want to why should I get dragged in front of the judge? But that's what we bear that burden. That's why you need to do what? Document, 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 write everything down. Keep all your records. You need to keep them for 3 years anyway. Keep everything. You show a list of houses, write them all down. If you have any conversations with them, make sure you take good notes. I might have said this before, but when we're done here, when our class is over, I spend 15 minutes taking notes of things we talked about, of where we went, questions that were asked. I had a human resource director tell me, if he didn't tell me once, he told me 1,000 times. And what he said to me is that the palest ink is better than the fondest memory. Write it down. You'll never remember all the details, and you need the details on your side. You need the details. If you're not organized and you don't take good notes right now, it's a practice you want to get into. It's a practice you want to get into, right? Because I bet there's half of this class. We have 27 people in here. Half of us, no notes, it didn't happen. Yeah. Half of us can't remember what we had for dinner on New Year's Eve. Now, after all of this goes to court, you think you're going to remember all the details? You're not going to remember all the details. If you have a document that says, yeah, this is exactly what went on, dated from there, you can remember. You went to court all those times. You write it down and put the details down. Put it in a booklet and save it just in case you need it again. So you need to have a good set of records. And I mean, really, for real estate, look, it's their biggest purchase. It is highly emotional. It is, they don't listen to you half the time anyway. It's like being married. They don't listen to you half the time anyway. But if it's that important, unless your wife is going to take you or your husband's going to take you to divorce court, they're going to take you and try to sue. If I can sue and get money out of you, well, then that'll ease my burden on purchasing this house, will it not? Yeah, so we spend a lot of time with courts. We don't want to, but that's their recourse. And our recourse is to abide by the law. So we have to make sure we understand that, right? All right, so dual agency, very important, all right? We have to act as this mediator. We have to be right down the middle. We can't work with one side more than another, all right? We want to stay there, so our client. So, all right, so that's dual agency. Now, we must disclose to both parties. Both parties have to agree to dual agency. If one party says, yes, we'll do dual agency, and the other party says, no, I don't want to do dual agency, well, you got to find another agent, or you got to tell them to go somewhere else. Okay, you can't. You need their agreement in writing on the documents. Now, in the listing agreement, we'll have that. We'll have a line for there. And the buyer's agency agreement, we'll have a line for that too. But if they say no, right? If they say no, before we can show that house, we have to get them both to say yes. So let's say I have a listing that says no dual agency, and then I have a buyer who's willing to pay cash and close in 30 days. I can go to my seller and say, hey, look, if you agree to dual agency, I got a buyer who's going to make you a fantastic offer. Would you agree to dual agency? Let me bring him over. I can't even show it. Let me bring him over. And he can agree. Now, these things aren't forever. It could be for just one, it could be for one house, one showing, one day, whatever. All right. But I need consent from both. And I need it signed off on. All right. I need it signed off on. All right. All right. So that's disclosed dual agency, both parties. Now, at no time can we have what's called undisclosed dual agency. We can't do that. I can't be representing the buyer and the seller and not have both parties know. It's against the law. Let's talk about designated dual agency. Buyer says, I don't want you representing, or the seller says, I don't want you representing both me and the buyer. I said, but I can do a good job. He said, I don't care. I don't want you doing that. All right. Well, let me see if I can figure something out. So I go back to my broker in charge, and I'm going to say, Mr. Broker, he's not going to let me do dual agency. And the broker says, all right, well, he let us do what's called designated agency. And we need a company policy to practice all of these: dual agency, designated agency, single agency. We can do them all, or we can do just one. We can do whatever. All right, we're going to need that. I say, yeah, I think he'll let us do that. So I go over and we say, okay, he'll sign, but I can't represent the buyer. My broker in charge is going to remain in dual agency because why? He got hired, right? The firm is been hired by the buyer and the seller. But what he doesn't want, what my seller doesn't want, is me working for both. So my broker in charge is going to find another agent in our house that are going to say, hey, look, would you want to be the other agent? Sam's going to take the seller. I need somebody to represent his buyer. And we'll both be working for the same broker in charge. And then we will both be separate parties. Okay. And then we would have designated agency. So let me show you kind of what this looks like. Here's our broker in charge. All right. I wanted to do it, but I took the seller. And over here, we have Reagan. She took the buyer for me, and she's going to work the buyer. Okay. My broker in charge still handles both of these clients, right? So technically, my broker in charge is still a dual agent. What they didn't want is me to handle both parties, so we just got Reagan and said, Reagan, would you help me out? And as long as Reagan doesn't have any confidential information about my seller, she can do that. Okay, she could do that. And she would represent the buyer full force. Remember the old car? She can give that buyer the old car: obedience, loyalty, disclosure, confidentiality, accounting, reasonable skill and care, right? It would be as if we worked separately, as if we didn't even work for the same company. I would be able to fully represent my client as the seller. She would be able to represent that client as the buyer. Okay. Now, let's look at this same diagram, and I know it's all choppy, and I apologize, but I did it to save time and space. What if I had the listing and Wayne brings the buyer? We work for the same company. Would that be the same thing? My broker in charge wouldn't even have to assign him. He would have the buyer, I would have the seller. Designated dual agency. We would have to let them both know that we are designated dual agents. We work for the same broker in charge who has both the buyer, who has been hired by both the buyer and the seller. Okay. So that would be what we would talk about. And we get them both to sign. All right. So your broker in charge carries a lot of weight here. Right. In this particular case, your broker in charge. And then we have Sam, who's the agent. Right. And that's agent one. And then Sam has both the seller client and the buyer client. Now we got to get both the buyer and the seller to sign a document that says Sam's going to work both sides, dual agents. This would be dual. Okay. On the other side of that, we would look at it and it works both ways. So broker in charge. Now both of us, let's say we said Wayne was going to do the other side. Okay. He's agent one. And Sam is going to represent the seller, right? The seller agent, Wayne's the buyer's agent. Wayne's going to bring the buyer. And Sam's got to bring this, has got the seller. We would tell the seller and the buyer that we have what's called designated agency. Because we both, who's been hired by both of these people? Our broker in charge, right? Our broker in charge has both. Okay. Yes, you need, and in both cases, Callie, that's a good point. You need written consent from both parties to show the and put an offer. We can't even show it if we don't have written consent to do it. Okay. So this would be designated agency. All right. And then we can go about making this deal. I would be able to give all 6 fiduciaries to my client. Wayne would be able to give 6 here. Over here, I can only do 3. Right? I cannot do old. I can do the car part. Over here, we can do both. It's as if we don't even know each other. Both are disclosed, yes. We have disclosed dual agency and disclosed designated agency. Anything that is undisclosed is illegal. You can't. Both the clients need you need written permission from both buyer and seller to do it. Okay. For the most part, good question. Do people normally agree to potential dual agency up front? Yeah, and so the only time, let me say this, if they trust you and they think you're a good agent, yeah, they're going to agree. If they think you have commission breath and you're not interested in their well-being, you're going to fight them. And I mean, and that's the reality of the world, right? But if they trust you, and they say, yeah, I think you'll do a good job for me, they'll sign it, right? But if they don't trust you, they're not going to sign it. They're not going to let you do it. Now, we usually get this, yeah, and the sad part of that, Kimberly, I would imagine many don't know even what that means. The sad part about it is when we start talking about the agency disclosure, which comes up probably in 2 or 3 slides here, we're supposed to give it to them before we sign anything. And not only give it to them, explain it to them and get their signature on it. You want to know how many agents really do that? Yes. In both cases, Sam is a sub-agent from the broker, right? Because he's the agent. Remember, he got hired? Wayne and I are both subs in this particular case. We're the agent of an agent. And that's why I can go over and work with the seller, because I would be an agent of their agent. Right? So yes, we'd be sub-agents. All right, let's carry on and we'll see how this makes a bit of sense here. Okay. Is the seller exclusive? No, So there's no such thing as oral seller's agency, oral listing. There's no such thing. Only buyer's agency. Okay, they have to sign the contract. The listing agreement is the contract, is the hiring agreement. Okay. All right, in-house and transactions only, obviously. We do need a written company policy, and that's with the firm, yes. Right, informed written consent of both parties. We need both parties to sign it. And the broker in charge can appoint different agents to help with the situation. And this is just, again, optional form of dual agency. Remember, the broker in charge stays in dual agency. It's just whether I'm handling both sides or not. If he has two agents that are handling his transaction in-house, that's dual agency. It's designated dual agency. Okay. All right, now what I said before about Reagan, though, comes to play here. It cannot be designated if, let's say Reagan went to do a, I got the listing, but Reagan, before I got there, did a listing appointment trying to get the listing, and they gave her a lot of information. So she knows now about the seller. She can't be the buyer's representative now. We'd have to find somebody else who didn't have any confidential information about the seller. I want to add a little fuel to the fire. You're going to get your license after you pass this test and the state test, and you're going to get what's called a provisional broker's license, which gives you the opportunity to work directly for a broker in charge. Okay. Until you do your 3 30-hour classes, your extra 90 hours, which will make you a full broker, you're going to be in provisional status. So you're going to work hand in hand with the broker in charge. They are going to be your sensei, if you will. All right. They're going to tell you what to do. They're going to show you what you do it. You're going to do it in their name. Now, here's the key. I want to, let's be very clear here. If Shanta is the broker in charge and I am the provisional broker, Shanta may buy and sell houses. She may have her own business, right? She's working for ABC company, but she buys and sells houses too. She is the broker in charge. I work with Shanta. I'm the provisional broker. If I'm working for Shanta and we get a listing, aren't we going to work together for the listing? She's going to show me what to do, right? She's going to teach me how to do it. The broker in charge brings a client, not with me, but on his own, brings a client to buy our listing, Remember we talked about that, the designated agency, the other party couldn't have confidential information on my party, right? If I was working directly with the broker in charge, would he have confidential information on the seller? And if he brought the buyer, would he still have confirmation on the seller? Yeah, he'd still have all that confidential information. So therefore, we, as a provisional broker, which would be me, and as the broker in charge, which would be Shanta, we would have to do this as dual agents, not as designated agents. Remember I said dual agents, we couldn't do the obedience, loyalty, and disclosure. We could do the confidentiality, accounting, and reasonable care. Okay, we can do that part. All right, but we can't give both of them full service because my broker in charge has full knowledge of what my seller has. We work together. A provisional broker and their own broker in charge may not be designated agents. They can be dual agents, but not designated. So that means that we would have to work this thing down the middle. We'd have to keep confidentiality. We'd have to make sure that we weren't leaning towards one buyer or the seller, whatever it was. We'd have to mediate, be in the middle, right? But in this particular case, what we're trying to prevent is the broker in charge representing his buyer and giving him all the information that he knows from the seller. Because why? He helped me put the listing together. He put all of that stuff in there. He did all of that work. So therefore, he's done all of that. He knows all of this. So if he knows that the seller will accept $50,000 less than his $1 million asking price, isn't he going to go tell us if he is a designated agent? Doesn't he have to give him all 6: obedience, loyalty, and disclosure? That would be under that disclosure line. Wouldn't he have to go to his client, his buyer client, and say, "Hey, offer 50,000 less. I know that that's what they'll take." Is that fair? That's not fair, right? So the provisional broker and their own broker in charge may not be designated agents. They can do it as dual agents. A broker in charge can be a designated agent with any other full broker. They're allowed to do that. A broker in charge can be a designated agent with another broker in charge for the same firm. A provisional broker can be a designated agent with any full broker. A provisional broker can be a designated agent with any provisional broker. Okay. He can only not be a designated agent with his own broker in charge. You might need that information again. Yes, because of the old, right? He's going to have to, because of disclosure, and it's more the D. What's going to happen is that if I'm going to be the broker in charge, and let's say Kerry was my provisional broker, and I said, "All right, let's go list this house. Come on, I'll work with you. I'll help you. I'll make you fill out the forms, and you'll know about it, and then that's great, okay? And you'll be able to do that." So I'm going to get all that information while she's filling out the forms. 3 days later, I have a buyer in town who I'm working on my own. I'm not working with Kerry with this one. And I'm going to bring them over to that house because they said they would do dual agency. I'm going to bring them over to the house. They said they would do dual agency. And at this point, I have to tell, if I could practice designated agency, I'd have to give them all a disclosure. By law, I have to tell them what? Everything I know about the seller, right? In designated agency, because I have to disclose. Well, in dual agency, we can't. We're not obedient, we're not loyal, we don't disclosure. I'm not saying not be nice and be fair and honest. You have to do that to everybody. But I don't have to disclose what the other party's got. So we can do this as dual agents. We may not do it as designated agents. Okay, it's how we act. Okay, so please write that down. That one shows up virtually every test, and it's confusing. So I want you to make sure that you understand that. Okay. Provisional broker cannot be a designated agent with their own broker in charge. Everybody else they can. And your broker in charge can be designated agent with everybody else except his own provisional broker. And again, we can have let's say I gave it to, we're going to do designated agent. I'm going to have the seller. Reagan has a team of 3. They all have licenses, but it's Reagan's team. They can help Reagan do whatever it is. We can have more than one person as a designated dual agent. All right. As long as they're a licensed assistant or whatever, it doesn't really have to be just one agent. It can be multiples. All right. Helping her out.
If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.